Hello, this is the talk on cosmopolitanism, just wars and law. Now, the rise of cosmopolitanism coincided with what sociologists call globalization, economists neoliberalism, and lawyers humanities law. Neoliberal capitalism formed the real, globalization the symbolic, and cosmopolitanism the imaginary order of our societies in the last 30 years. In the absence of a political blueprint, cosmopolitanism, an ancient philosophical tradition, has been resurrected and became the latest fashion of social and political theory. According to its apologists, when the twin projects of international and cosmopolitan law have been fully implemented across the globe, the Kantian promise of perpetual peace will come close to fulfillment. Cosmopolitan capitalism is presented as globalization with a human face. Cosmopolitanism humanizes inequalities, softens the side effects of globalization, limits oppressive and totalitarian regimes. This talk examines the military morality of just wars and cosmopolitanism, one facet of the wider moralization of politics, both domestic and international, since 1989. Let me start with a brief text. I quote, "The military planners of the war were under huge political pressure to prevent casualties on their side. This was achieved by increasing the collateral damage among civilians. A few weeks after the start of the war, an Air Force general told reporters that it was necessary for the success of operations to break the morale of civilians. His tactic would be, you won't have electricity for your refrigerators, you won't have gas for the stove, you won't be able to go to work because the bridge will have been demolished. Those have to go. Civil targets are easier to identify at bomb. Bridges destroyed, television and radio stations, hospitals, schools and kindergartens, cultural, economic and industrial facilities, infrastructure for computer networks and power stations. The bombing of a major capital, supposedly to protect people hundreds of kilometers away, was something beyond reason and morality." Now, you may think that this passage refers to Russia's war in Ukraine. It is wrong, I'm afraid. It comes from the book entitled Human Rights and Empire and refers to the war in Kosovo, not Ukraine. A second vignette. On March 16 this year, the International Court of Justice ordered Russia to immediately suspend its military operations in a case brought by Ukraine under the Genocide Convention. The court noted the civilian deaths, the material damage, the increasingly difficult living conditions for civilians, all of which raise very serious issues of international law. It rejected the formal claim that Russia is acting in self-defense and stated that it has no evidence that a genocide has been committed in Ukraine. It was a comprehensive defeat for Russia. But it was also a comprehensive defeat for the international court and indeed international law. The law was treated with contempt by Russia. Most people have not even heard about the judgment of the court and the order for Russia to desist. I believe that the disregard for international law in this court has been prepared by various cosmopolitan claims linking what happened to Kosovo and what is happening now in Ukraine. When Crimea seceded from Ukraine, the secessionists used extensively a decision of the International Court in 2008, according to which Kosovo's secession from Serbia did not violate international law. The affinity between Kosovo, Crimea, and Ukraine is the outcome of the combination, the articulation of two historical trajectories, the long one of bellum justum, or just war, the more recent one of cosmopolitanism, contemporary cosmopolitanism. The stakes, of course, could not be greater. It is the relationship between politics, morality, and law in the ultimate test of humanity, war. What normative order, what morality and justice lies behind war? Just wars. Throughout history, people have gone to wars and sacrificed themselves for religion, empire, nation, or ideology. Religious and secular leaders know well the importance of adding high principle to low ends. It is evident in Homer's Iliad, in Thucydides' chilling description of the Athenian atrocities in Melos and Mytilene, in the Chronicles of the Crusades, in Shakespeare, Brecht, and the many films about our recent wars. Empire builders and colonialists, the Americans in Iraq and the Russians in Ukraine are not devoid, of course, of moral rhetoric. Putin claims that he invaded Ukraine to save the Russian speakers and the Russophiles from genocide. Of course, the same accusation is leveled more convincingly by the Ukrainians against the Russians. The hawks have always put on the fleece of moralists to persuade soldiers and citizens about the value of killing and dying for the cause. As the poet Wyndham Lewis put it, but what war that was ever fought was an unjust war, except, of course, that waged by the enemy. The lack of a moral arbiter has made just war the hardest moral maze. For the warring parties, there is nothing more certain than the morality of their course. For third parties, there is nothing more uncertain than the rightness of the combatants' conflicting moral claims. This ambiguity becomes evident in the history of just war. Pre-modern societies had no law of war. The customs of tribe, of polis, or empire determined the correct way for starting the war, for its conduct, and for the treatment of opponents, of prisoners, and of the dead. The Iliad or Antigone offer ample evidence of such customs that existed in all pre-modern societies and communities. The formal concept of just war, bellum justum, appeared in Rome. Before the beginning of hostilities, the Fetials, a college of priests, determined whether the conditions of going to war existed and performed certain legal and religious practices. These practices brought together sacred functions, religious rituals, and a modicum of legal regulation. All three are still with us today. The first consistent theory of just war was developed by the early church in an attempt to serve Caesar without abandoning totally its pledges to God. It was the church, an institution devoted to love and to peace, that first blessed war by defining it as just and the circumstances in which this happens. For Augustine, a just war redresses a moral wrong and restores the violated moral order of Christian natural law. War must be declared if first a legal and legitimate authority declares it as a last resort. Second, the war must have a justa causa, a just cause. Wars were considered just if conducted in self-defense or for the restitution or retribution after an unjust act by the enemy. Finally, the war should have a reasonable prospect of success. Medieval theology anchored the jus ad bellum, the just initiation of war, on the jus commune, on the common law. This was, at that point, the universally applicable Christian natural law, and of course, a shared view amongst Christians and amongst Christian monarchs and kings and princes about what counts as the common good. This medieval theology neglected the jus in bello, the lawful conduct of war. The divine duty to punish infidels and evildoers made the prosecution of war limitless in the unremitting violence of the Crusades, the genocidal attacks on Indians and the indigenous people in the New World, and of course in the colonies as part of the civilizing and proselytizing mission. For the theologians who applied God's perspective, God's view of the world and God's law, only one of the warring parties could be right. This, however, changed in the 17th and the 18th century after the Reformation. A new European political order emerged of antagonistic emperors, kings, and priests. After the Reformation, sovereigns of various denominations emerged and waged religious wars of great cruelty and barbarism. The philosopher Alasdair MacIntyre called the coming of modernity a moral catastrophe. The Western common religion was replaced by multiple religions, God by the sovereign, the ethics of virtue and the common good by plural and relative values, eschatology by philosophies of history. Humanity became its own metaphysical ground. Now, the great achievement of modern law in this new situation, as mainstream jurisprudence argues, it was to create a kind of neutral mechanism, a neutral legal mechanism against the clamor of religious wars and the polyphony of values, of moral and cultural values that emerged in early modernity. Morality, the common morality, was demoted. It became personal and subjective, something that people do on a Sunday or the Sabbath, as Marx would put it in a different setting. It was and is an unreliable guide to public action. State law excluded morality and ideology from its operations, or so it claimed, in order to appear neutral, a procedure acceptable to all the parties involved in a legal dispute. Law is supposed to turn social conflict and political conflict into technical questions about the meaning of rules to be decided by rule experts, lawyers, judges, and other type of legal professionals. This was law's claim, but it was not the reality. The supposed neutrality and lack of morality and ideology was and still remains the greater ideology supporting law. If we turn to international law, there too, the emerging jus publicum Europaeum, the public European law, abandoned the moral view of the world that was promoted up until early modernity by the church. The centrality of sovereignty, the treaty-based character of international law, and the realpolitik of international relations are all amoral. Indeed, the conventional nature of international law exemplifies the emphasis placed in modernity upon the state and autonomy, upon the state and the autonomy both of individual states, independent states, and of course, independent free individuals. In domestic law, contracts can exceptionally modify, change, alter provisions of state statutory law. In international law, on the other hand, contracts, that is, treaties and conventions amongst states, is what creates the law. So the idea of individual independent states and their ability and their sovereignty, their jurisdiction to create the law is absolutely central to international law, and to that extent exemplifies those aspects, ideological aspects of modernity. The lawyers therefore abandoned the search for what can make a war just, the only judge of the justice of the cause and of the war was and is the sovereign, the state. Both warring sovereigns could believe in the new legal dispensation, unreasonably, of course, but legally validly, that their cause was just, because according to the law, they were formally equal enemies, hostes equalitur justi, because they were both sovereigns. The question of who is right and who is wrong, who is just and who is unjust, does not arise. They can both go to war, and the question of justice has no relevance to the conduct of war. And so emphasis shifted from the cause of war, from just war, to the development of a jus in bello, legal rules and regulations that would protect the monarchs from certain undesirable consequences during the conduct of war. For example, ambassadors and envoys were given certain protections. War prisoners were spared from death. The beginning of principles like discrimination and proportionality, which regulate the conduct of the war, particularly towards civilians and towards property. That kind of idea started emerging in order to regulate the conduct of war without, of course, overburdening the warring parties. This new law of war was seen as a kind of concession by the different European sovereigns and an implicit agreement amongst them in order to avoid certain repercussions that could actually be harmful to both combatants in a war. So sovereignty replaced divine omnipotence, state-made law replaced morality. War brought states to life physically, as most states in early modernity, and of course all the way to the 20th century, have been the outcome of war or revolution or secession, the outcome of violence, of course. Second, war brings states to life metaphorically, because it energizes and unites populations behind the flag, behind the sovereign, behind the claims that the sovereign and ideology puts forward for the war. And finally, as Hegel put it so strongly in the Phenomenology, war also helps metaphysically by raising people to the universal through their confrontation with death. You may remember these wonderful passages in the Phenomenology that people are really bored and involved and embedded in daily unimportant activities, and then suddenly war and the confrontation, anticipation of apprehension of death brings them up to the general, to the universal, and they become philosophically much more wise. The sovereign accomplishes its nature by declaring and waging war. War acts as the litmus test also, according to many authors, from Machiavelli and Hitler to contemporary authors who have said that, for example, in England, masculinity has suffered because there has not been any major war in the last 60, 70 years, which is not true anyway. But anyway, the idea is that war is to men what maternity is to women. So war is part of the Western symbolic, lies at the creation of states, and plays a role of bringing together different aspects of social and personal life. Now, Kant, who wanted war abolished, despised the pragmatism of the lawyers, those lawyers like Grotius, who had accepted the power of kings and princes and monarchs to declare law and would not himself, Grotius, and the other international lawyers would never challenge the power of kingship to start law. So Kant, who was for peace, attacked Grotius, the father, one of the fathers of international law, as a miserable comforter of kings. For Kant, reason condemns war. Morality ordains not just war, but just peace. Force can be used morally in very few, if any, cases. The aim of cosmopolitan society, which Kant was the first to evangelize in modernity, was defined negatively: the abolition of war and perpetual peace. His contemporary followers did not follow, I'm afraid. Now, the 20th century changed the picture. The desire to prevent war returned. The first count in the Nuremberg indictment was for crimes against peace, in other words, waging unjust war. Under Chapter 7 of the United Nations Charter, war is unlawful unless in self-defense or on the authorization of the Security Council. In this sense, just war theory returned from the back door. The arbiter now was not religion or morality, but international law, which, as we said, formerly in the past, since its creation in modernity, was supposed to be devoid of morality, with no morality in it. If God is dead, according to this new dispensation, as Nietzsche said, he has been replaced by international lawyers. The post-war legal order, however, was based on two contradictory principles. The first was a moral claim to protect universal human rights, but this was accompanied by the principle of non-intervention in the internal affairs of states, by the inviolability of sovereignty. So you had, on the one hand, universal morality, on the other, state-based sovereignty, and the inability, the lack of any excuse in other states to intervene into the sovereign territory. Now, in 1945, states, of course, cared very much for their sovereignty, particularly as the period of decolonization was about to start, and the idea of having full independence, full self-determination, and inviolable sovereignty was extremely important. Indeed, while human rights were introduced in the United Nations and then in 1948 in the Universal Declaration, they were recently invented and therefore were seen as largely irrelevant to the international order. Now, the attempt to codify legally crimes against peace, which is a double negative for unjust war, a crime against peace, is the beginning, the unjust beginning of war. So a kind of backdoor definition of just war. But this attempt to codify crimes against peace, which, as I said, were part of the Nuremberg and Tokyo trials against war criminals, that failed. And it failed because any strong and strict legal definition would be a double-edged sword for the major powers, who knew that they would repeatedly intervene in their spheres of influence. And of course, with the beginning of the Cold War, the two superpowers had their own kind of satellites, and it was more or less accepted that a superpower can intervene in a satellite that is not following the line. And therefore, during the Cold War, the superpowers and their followers would use the veto power in the Security Council. The 5 members included, of course, the United States, Russia, China, and Britain, United Kingdom, and France. And therefore, the two sides of the Cold War could always stop any legal authorization, any United Nations authorization to start a war that the other side would attempt against your own followers. So while just war theory returned with human rights, with the failing attempt to define crimes against peace, unjust wars continued. cosmopolitanism now. This all changed with the fall of communism. The New World Order, announced in 1989, reinvented cosmopolitanism and presented it as the future of humanity. International law, international institutions, human rights, a global civil society supposedly would replace the atrocious 20th century international community with the promise of moralized politics, international politics, and world peace. For liberal philosophers, human rights are a new universal morality. In the 19th century already, Auguste Comte and Émile Durkheim had declared human rights the religion of modernity. I have discussed elsewhere in a number of books, Human Rights and Empire, The End of Human Rights, The Radical Philosophy of Rights, the Christian origins and the sacred nature of human rights, which of course is now being sharply and so I think offensively advertised in the argument over abortion in the United States. International lawyer Ruti Teitel claimed early in the 21st century that a new jus commune, a new common law, international common law emerged in the 21st century, and she called it humanities law. So humanities law excuse me for this short interruption. We're going back to Ruti Teitel, who claimed that a new jus commune, humanities law emerged in the 21st century and brings together the law of war, the law for the conduct of war that we mentioned, which has been further developed in a number of international conventions, particularly the Geneva Treaties, and on the other hand, the law of human rights. Those two types of legal systems, human rights and the law of war, apply throughout the world and independent of the state a particular country is in, whether at war or at peace. Both these systems of law puncture the border of states, and of course, when we end up with humanitarian wars, military force is being placed in the service of morality. This is humanity's law. In humanitarian wars, humanity kills in order to save humanity. Now, after the Kosovo War, a major debate addressed the legal status of that war. Eminent professors, amongst them Cassese, Sima, and Glennon, expressed the dominant Western view. NATO's war was illegal but legitimate. Morality had to be introduced because a moral international law, an international law that up until that point did not accept the idea of protecting victims of a particularly atrocious regime by intervening in the state, that this type of law had to be changed. The law, according to the lawyers, on its own could not save humanity, and therefore morality had to be introduced. Now, Jürgen Habermas, the contemporary heir of Kant, did not follow the master in this matter. Habermas agreed that Kosovo pushed international law towards its cosmopolitan phase. It was an illegal war, but the Kosovo principle of intervening in order to save victims had to be generalized and to move forward. Now, of course, for Habermas, the ghost of Carl Schmitt is always in the background. It is persecuting him. So Habermas accepts the claim by Schmitt that the moralization of politics could lead into a huge arbitrariness by the powerful. He accepts, although not explicitly, the famous saying that people who invoke humanity cheat. Habermas therefore reversed the solution of the lawyers. He bifurcated human rights into two components, a Kantian moral component, a moral justification, and then a legal, juridical component. And only for Habermas, the legal part, the legal aspect of human rights, not the moral part, should be grafted onto international law and then move that law to its cosmopolitan phase. For the lawyers, morality saves politics from inadequate and amoral law. For Habermas, human rights law saves politics from a problematic moralization. The intellectual contortions indicate that the matter is in equal measure grave and hard to resolve. I should add here, of course, that after the Iraq War, Habermas conceded that the United States, the pacemaker of progress on the cosmopolitan plan after Kosovo, has given up its role as guarantor of international rights. Its normative authority lies in ruins. He concluded that classical imperialism and American hegemonies are not that dissimilar. An international commission then was charged to find a way through the moral maze of when a humanitarian intervention, a war to save victims, can lawfully occur. And of course, at the time Iraq had taken place, it was very clear Iraq was illegal. It was very clear that the Iraq invasion and occupation was based both on a totally false prospectus about weapons of mass destruction, but also it had led to a huge catastrophe of the country. So in 2005, this international commission came up with the concept of responsibility to protect. The commission, sorry, let me correct myself, the commission concluded in 2001, and then a United Nations summit meeting in 2005 after Iraq concluded this process of adopting a new concept, the responsibility to protect. The responsibility to protect places the prime responsibility on the state, on a state's government to protect its own population from genocide, crimes against humanity, war crimes, and ethnic cleansing. To that extent, it's a rather commonsensical statement of what a government and the state must do towards its citizens and the population. Of course, they must protect them from these grave crimes. Now, the doctrine continues that if the state fails to protect its own citizens and population, the international community may use sanctions and military intervention, which, however, again, must be authorized by the Security Council with its important veto power, the veto power of the 5 permanent members. So the doctrine legitimized the moralization of war. It accepted that, occasionally powers may intervene in another state for moral reasons. And that was a major victory for the Western powers that had already exercised it in Kosovo and elsewhere. But the retention of the veto was a concession to national political priorities. In 1945, the law placed emphasis on sovereignty and introduced, but rather sidestepped, human rights. In 2005, it placed emphasis on morality, but retained sovereignty as a part of this new arrangement. The Western powers wanted to create a new moral law that allowed them, as the main agents and power players, to intervene whenever they thought it was necessary. But the developing world did not welcome this new dispensation and insisted that the Security Council, which is a rather truncated forum for the expression of sovereign interests, but still a forum in which states speak from their particular position of interest, that states would remain part of this new arrangement through the Security Council. The Western assumption was that in the New World Order after 1989, everyone would accept the ideology of America and go along with the wars that America thought they were moral or necessary. So while in the 17th century, new denominations challenged the hegemony of the church and removed morality, inserting sovereign interests in law, in the 21st, the many religions and cultures that do not share necessarily the ideology of the West or the dominant interpretation of the law accepted the readmission of morality only on condition that sovereign interests were retained. In 2011, the United Nations Security Council used RTP, Responsibility to Protect Technology, to authorize a military intervention in Libya to protect civilians, but explicitly rejecting the use of violence for regime change purposes. There was, of course, the president of Iraq. Now, the United States, the United Kingdom, and France moved soon, which took over this authorization and started intervening and bombing Libya, soon moved to support the anti-Gaddafi forces. And eventually, we were led to chaos and heavy civilian casualties, and the chaos in Libya is still there today. So when war came to Syria now, Russia and China vetoed the resolution to use violence. They had not vetoed the resolution on Libya. Now they veto it. And the responsibility to protect their claim had been abused and became a pretext for overthrowing Gaddafi. Libya was the first time this new doctrine was invoked, and I think it is unlikely to be invoked again. Let us move to the present time. As we know, earlier this year, Russia unleashed extreme violence against Ukraine, supposedly to defend Russian-speaking and Russophile citizens from genocide, and indeed to annex parts of Ukrainian territory. Russia models its military expansion on the law created by the West. Its intervention in Georgia in 2008, the unilateral declarations of independence by Abkhazia, South Ossetia, and Crimea referred to the precedent of Kosovo's unilateral secession from Serbia in 2008. Russia has rhetorically accepted the Western normative order, but does not accept the dominant interpretation the West places on it. Russia promotes its own understanding, both of facts of what is happening on the ground, and of course, its own understanding of the humanitarian moral values that the new law and the new world order supposedly is promoting. Let me conclude. In the first part of the 20th century, liberals tried to abolish or to limit war, following the lead of Kant, of Immanuel Kant, their master. They mobilized law, legal restraints, institutional barriers, diplomacy, and of course, collective security to limit war. The moralization of international law, on the other hand, shifted the goal from ending war to ending human rights violations. State law is national, while human rights have been declared as the new jus commune, the new common law, and therefore they are universal. The prevailing interpretation remains in the hands of the great powers, which of course can use human rights and the new common law for their non-moral purposes or for their interests. The universal moral order supposedly operates above states, but it can only be imposed by powerful sovereign states upon others. Humanitarian intervention normalizes war and erodes the legal and procedural restraints on the use of force. It creates precedents which are then used by others against the prevailing interpretation. Humanitarianism, in this sense, has become the contemporary version of the civilizing mission. Wars in its name have caused untold human suffering in Kosovo, Iraq, Libya, and of course now in Ukraine. I'm not arguing, of course, that the cosmopolitan order is to blame for the appalling Russian aggression against Ukraine. It is one of the reasons, however, for the disregard and the degrading of international law. Law and international politics are conducted on separate and seemingly unrelated planes. Law in texts, in norms, and in philosophical texts from Kant today to John Rawls or Habermas. Politics is exercise conducted in power relations, in war, and in utilitarianism, in Bentham. The law is valid, international law is valid, but inapplicable in an almost permanent state of exception. War cannot be moral or humanitarian. What the Russians are doing in Ukraine and what the West did in Kosovo, Iraq, and Libya is reprehensible. Civilian deaths by the machine guns of proud Russian speakers and proud Kosovars, or by the fighter planes of imperialist Russians or humanitarian Americans, are equally murderous. Of course, we may have our own views about who is right and wrong in the present war or any war, but our solidarity must extend to the victims of war wherever they come from, and there is more. What connects ordinary people in Ukraine, Russia, Poland, or United Kingdom, or any other country, is that we're all governed, we're all ruled. A right of the governed emerges out of the collectivity of the ruled, who express and act their independence and solidarity. The global community of the ruled has a duty and a right to intervene with protests, with insurrections, with pressure on their own governments, and with solidarity of the victims of wars. The rights of the ruled are defenses against power, but unlike human rights, they do not derive from the sovereign or its monopoly of violence. Instead, they are produced at specific historical moments by groups of we people who are governed, who are ruled, and then they are used strategically when people try to defend themselves. And there is precedent. The first cosmopolitanism was critical and even antinomian, because the nomoi, the laws, and the institutions of the age were falling far short of the ideals of justice and law, according to the philosophers of the 4th and the 5th century BC, which introduced the idea of cosmopolitanism. The alternative to the polis was the cosmos, not as a better arrangement of institutions, but as the place where gods and men come together and where laws express naturally the integrity of the relations between human and divine, today between the ruled, the victims, and the resistors. Diogenes, who first used the term cosmopolitis, described himself as cityless, homeless, without issue, poor, wandering man who lives from day to day, and added that he does not feel at home anywhere except in the cosmos itself. The cosmopolis is not situated in a particular place. It can be everywhere and nowhere. Its citizens are errant, nomadic, wise. Today they would be refugees, migrants, itinerants, critics. We, the ruled, who do not trust our rulers, wherever they come from. We, the critics, who put together our understanding, our theory, and our politics in the fight for a world without wars, humanitarian or otherwise. What binds me to a Ukrainian under attack, a Russian dissident, a Palestinian, a Syrian, or a so-called bogus refugee is not membership of humanity or citizenship. What binds my world to that of others is our absolute singularity and total responsibility beyond citizen and human, beyond national and international. The cosmopolitanism to come is neither the achievement of humanity nor a federation of nations, the European Union writ large. It is neither a form or a right, nor a constitutional arrangement. The cosmos to come is the world of each unique of us, of whoever or anyone, the polis, the infinite number of encounters of singularities. This cosmopolitanism avenir is what the really existent cosmopolitanism of today denies and prevents. We, the critics, we, the resistors, we who really condemn the war in Ukraine and the violence against people, are together united in order to try and achieve such a new cosmopolitanism that is also the most ancient one and takes us back to the tradition. Thank you.